Very good afternoon, ladies and gentlemen. I have got colds during the weekend, so my voice may not be the one you have heard, you are used to. It is really my great pleasure and at the same time honor to introduce Professor Asif Qureshi from Korean University Law School. He's actually one of very few most influential international scholars in the fields of international economic law. He used to teach at the University of Manchester for a long time, but until last semester, and this semester, he has moved to Korea University as a full-time professor. And it is our prestige to have him on our campus to teach students and to have his excellent academic performances. And it is really, therefore, my great pleasure and honor to have him and to have discussion about defining international economic law in our times. So why don't you welcome him by big hands.
Dean Park and ladies and gentlemen, thank you very much for that warm welcome, and I'm sure I don't deserve that warm introduction. And thank you for this opportunity to be able to speak on international economic law generally. When I first suggested this title to Professor Dean, defining international economic law in our times, I got the distinct impression from him that he thought the title was theoretical, fundamental, and of little direct relevance to contemporary issues and to Korea. In short, Dean Park wanted me to speak about something substantive and of contemporary relevance, something, for example, on the Samsung-Apple litigation, or on a possible dispute with the European Union in terms of Korean automobile exports and a possible anti-dumping action. But pretending not to understand Korean, although Dean Park clearly spoke and expressed his desire in English, I've gone on to speak about my chosen topic, but wanting to be on the right side of Professor Dean Park, and of course to reflect on the nature of his suggestions. I'm pleased to inform that I have been forced to rethink how one should engage in the defining international economic law and international economic relations from a contemporary perspective, taking into account substantive examples. So I'm grateful to Professor Park for forcing me to think in that way. I just hope I can do justice to the topic in clearly expressing myself with respect to what I have to say. At the outset, however, nevertheless, I would say that defining international economic law is one of the most profound of inquiries in international economic relations. It is highly relevant to informing responses to contemporary international economic problems, and it is manifest in all manner of systemic issues and problems in international economic relations. Right down to foreign economic trade concerns that concern Korea or the European Union or any other country for that matter. So what does it mean to define international economic law? and what does it mean to engage in this from a substantive and contemporary perspective. Imagine you are the general counsel of Samsung, and you are invited to advise Samsung on the Samsung-Apple litigation with respect to intellectual property right issues that have taken place in various domestic jurisdictions. You are invited to advise whether in international economic law there is something, some standard that could inhibit the litigation initiated by Apple. Imagine that you are the advisor to Hyundai, and the Hyundai Corporation considers that price policy of the Hyundai motor industry is a matter of commercial policy of the Hyundai Automobile Corporation, and furthermore that the Korean automobile industry wishes to be involved in participating in the European Union, who have concerns about dumping practices from Korean automobile industry, participating in the responses that the European Union embarks upon with respect to foreign exports to the European Union. What advice do you give to the Hyundai Corporation? You are the Director General of the WTO. The WTO is currently, as you are all aware, engaged in negotiating the Doha round of trade negotiations with a development agenda. And you are faced with pressure from developed countries to retain the trade nature of the WTO as an organization, and you are under pressure from developing countries to turn this organization, this trade organization, into an instrument for development. What course of action do you take? How do you respond to these competing pressures? You are a member of the WTO, and you wish the international economic system to echo international distributive justice. You wish the international economic system to be such that it provides assistance to developing countries in all its spheres, and you wish to provide preferential access to your services market to North Korea. North Korea is a developing country, but it is not a least developed country as defined in the UN Charter. How do you react to this when the WTO waiver to the services agreement prevents you from allowing access to North Korea on a preferential basis in the services sector because it's not a least developed country? You are the Director General of the WTO, an organization charged with multilateral trade governance, and you are aware that there are some 400 or so preferential trade agreements, regional trade agreements, which have mushroomed, and each one of, and many of them have special chapters dealing with non-trade issues such as human rights, labor standards, environmental standards. And therefore, you have different preferential trade agreements with different policy agenda, which has an impact on the coherence of the multilateral trade system, which has an impact on international trade. How do you face this challenge of fragmentation in policy making that has come about, that is taking place through preferential trade agreements? So these are the real systemic types of questions that engage the question of defining international economic law. in terms of Samsung and Apple, the question is, what are the sources of international economic law that are relevant in terms of this dispute? Are there any international standards that are relevant? In terms of the Korean exports, there are two different questions. One, whether competition policy is the concern of the international community, and second, whether relevant stakeholders, be they foreign or local, can participate in the formulation of foreign economic policy making. In the case of the WTO, the question whether it is a trade organization or a development institution depends on how you perceive the aims and objectives of the WTO, what underpins the international economic system in terms of aims and objectives. In terms of North Korea, it begs the question, what is a developing country? What is a developed country? What is a least developed country? And should international economic law be guided by principles of international distributive justice? With respect to the International Monetary Fund, the 2008 financial crisis, which the IMF failed to spot, failed to prevent, it begs the question, how do you define monetary issues as opposed to financial issues, a subset of subject matter of international economic law? Again, with respect to the various frameworks set up in preferential trade agreements, the question about coherence and the challenge to coherence and the relationship between non-trade issues and trade issues comes into play. So the process of engaging in defining international economic law is actually fairly complex, multifaceted, and involves and engages a number of questions. It is not just about what is international economic law. It is also about what ought to be international economic law, and it is also about the question, where should relevant decision making in terms of governance in international economic relations be set, whether at the level of the state, the level of individuals, or the level of regional integration organizations, or at a multilateral level. So what is international economic law? There are a number of questions here in terms of the sources of international economic law, in terms of what the subject matter and legitimate concern of international economic law is, who are the subjects of international economic law, how should international economic law be redefined, because constantly this is what is taking place. We are constantly engaged in trying to understand and redefine international economic law and the international economic system in the way that we wish it to evolve. And sometimes the question is and ought are conflated by commentators. So how should international economic law be defined in terms of the sources of international law, in terms of the subject and subject matter, in terms of its objectives? Moreover, the question of defining international economic law relates not only to defining international economic law at a global level, but it also is about defining the subsets of regimes and disciplines within the international economic system. So how should these subsets of regimes be defined, and what is their relationship to each other in the international economic system? How should they be configured in terms of general international law and non-economic subsystems? So these are the questions that are implicated when one thinks about defining international economic law. let's just try and reflect upon these questions in terms of some of the examples that I have. I will pick just three of the sets of examples that I've given to explain what it is that is implicated generally and theoretically what is economic law. So just to summarize, the question of definition involves considering what the sources of international economic law are, what the relationship between subsets of international economic systems are, what the subjects of international law are. So firstly, the areas that I would like to reflect on are sources of international economic law, the fragmentation of international law and international economic law, and this question whether or not the World Trade Organization is a developed institution or a trade institution. Now, there has been a very lively debate, not just in the past, but also an ongoing debate amongst international economic lawyers as to what are the sources of international economic law. This question, what are the sources of international economic law? Aspects. One is what is the content of international economic law? What are the legitimate concerns of international economic governance? And in the past, this has been done in a list of subjects. So commentators normally describe international economic law as being concerned with monetary law, with trade law, with investment law. In fact, Schwartzberg, one of the doyens of international economic law in the 60s, when he defined international economic law, he specifically excluded intellectual property rights and labor standards as not being the concern of international economic law and relations. The modern view of the subject matter, of course, of international economic law is much more wider and indeed encompasses even non-economic aspects that concern economic issues. In terms of the sources of international law, there are essentially two schools of thought about what the sources of international economic law are. On the one hand, international economic law is defined as a specialist or a specialism of public international law. And on the other, international economic law is defined as encompassing both national law and international economic law. So as to encompass not just public international law, but also transnational business law, custom, private international law. I'm assuming that this audience has some understanding what is public international law. As you know, public international law is the law that governs the relations mainly of states. It governs the relations mainly of states, whereas domestic law is concerned with more individuals, private entities, not the conduct of the state. And the traditional sources of public international law, as you may be aware, are set in treaties, in customary international law, and general principles of law. So why this dichotomy, this difference of opinion between international lawyers as to what are the sources of international economic law, whether it is public international law or both public and domestic law? What is it that goes into the argument that international economic law should be defined broadly to include private international law or domestic law, as well as public international law? The argument runs as follows here, that one should not define a subject according to the origins of the sources of law, but rather one should define the subject with respect to the totality of all the legal principles that apply to the particular problem. And moreover, and latterly, for example, U. Petersman in particular, the view is advanced that if you define international economic law in terms of public international law, you are in some way taking a top-down approach to defining international economic law. You are putting a premium on the state and a state-driven international economic system. If you define international economic law as being part of public international law, you are putting emphasis on the state and the state's ability to formulate and engage in international economic relations and norm creation in that field. Moreover, the argument runs that there is actually a convergence between public international law and domestic law. There is a convergence because some of the key principles, for example, state immunity, are now restrictively defined in international law, so that states have become the subject of litigation initiated by individuals. States can be subject for their commercial relations. They are subject to domestic law proceedings, which wasn't the case in the past. Moreover, it is recognized that international law ultimately is concerned with individuals, and therefore, because it is concerned with individuals, there should be a convergence of international law and domestic law, that these two should be reevaluated, that international law should be reevaluated. It is more responsive to and focused on the individual. In terms of international economic relations, moreover, the argument runs that you define international economic law both as public and domestic law. You put emphasis also on market forces and on the individual. You arm the individual, not simply in the policy formulation with respect to international relations, given that international economic law cross-border issues that involve individuals. Yeah? My is that one should keep, as a lawyer, from a legal perspective, one should keep distinctions between systems of law. Public international law is a different system of law, and domestic law is a different system of law. So for the purposes of the integrity of the disciplines, it is not possible to conflate the two. In fact, the school that international economic law is both public international law and domestic law is actually not a description of what is international economic law, in my view. It is aspirational in the sense that it is an argument for changing international economic law to be more responsive to the individual, to market forces, and not in terms of the state. So that was theory, general. In terms of Samsung and Apple, you are all, I think, aware of the facts of the Samsung and Apple dispute, lawsuit with respect to IPR issues in different jurisdictions, including US, Japan, and the United Kingdom. And so the issues raised involve intellectual property rights, protection, and domestic competition practice. And what is at stake? Consumer interests are at stake, domestic industry interests are at stake, and foreign investment in international trade is at stake. These are the issues that this case involves. Does it concern international economic law? Does it concern international economic policy making? Certainly, IPR issues may be described as being of domestic concern at some level, provided a state conforms to the minimum requirements of intellectual property protection that the TRIPS agreement in the WTO assures. States have a fair degree of discretion as to the level of intellectual property rights they offer. States likewise have a fair degree of discretion in terms of due process and adjudication with respect to intellectual property right issues, provided they conform to minimum requirements in international law of due process and fair play. So, for example, whether an IPR dispute is resolved through a jury system, as it was in the United States, or through a legal expert, a judge, legally qualified judge, that really falls within the domain of the state itself. International law allows that degree of discretion. But certainly, as a matter of international economic relations, this dispute has an impact on the flow of international trade. This dispute has an impact on the flow of international investment issues, and arguably it may raise questions of human rights in terms of intellectual property rights. Does it concern public international law? Does it involve or implicate any international agreements? If there are violations of the TRIPS agreement, yes. If there are violations of minimum standards and judicial processes in customary international law or in the TRIPS agreement, yes. If there are any violations of multilateral intellectual property right conventions, then it concerns international law. It may also implicate investment chapters in free trade agreements that Korea is a party to, and the United States is a party to. So the question whether the issues raised by Samsung-Apple litigation is a concern of international economic law is really dependent on how you define the sources of international economic law and the subject matter that it is concerned with. So you can see when I was initially asked to talk about Samsung and Apple, my reaction as an international lawyer was to say, well, hang on here, I'm really a public international lawyer. This is a dispute that doesn't concern me. It doesn't come within the domain of my expertise, but I've had to revise my impression of those sets of facts in terms of the sources of international economic law. Moving on, I'll be quick, I think, with respect to this question of fragmentation. As you are aware, public international law has become fragmented. International lawyers are very concerned about the fact that you have now different regimes. You have international human rights law, you have international environmental law, you have air and space law, you have international labor law, you have different regimes of legal systems dealing with different issues in public international law. And in the same way, international economic law has become fragmented. It is fragmented in terms of investment law, trade law, development law, international labor law, and so on. This fragmentation is a consequence of the fact that of specialization, firstly, and of the fact that inevitably norm creation has been through treaty, through international agreements, through multilateral agreements. And because it has been a consequence of treaty, what we have now, and because of the absence of any centralized system of norm creation, we have a situation where international economic law is fragmented, as is public international law fragmented. And the consequence of that has been that there is overlap of policy, of law, clashes of norms, forum shopping, that is to say that litigants are shopping into different regimes of disciplines and courts which give them the best advantage in litigation. But the other problem, of course, of fragmentation is that you have these developments that challenge the coherence, the underlying coherence of international economic law and the international economic system. You have, on the one hand, the objectives of the international economic system, and on the other hand, you have the objectives of the subsystems that have been created in this fragmented picture. Because the way these subsets of regimes have evolved, they have not thought through how they relate to other disciplines, to other regimes. And so there have been various disputes as a consequence. In the WTO US shrimps case involving shrimp exports to the United States, there were conflicts between trade norms and environmental norms, trade issues and environmental issues. The appellate body had to pick and choose how it will steer the decision. In the EC hormones case in the WTO, again, the appellate body had to consider the trade agenda of the WTO and also the environmental measure, in particular the precautionary principle that the European Union invoked in order to justify the ban on hormone-treated US beef into the European Union. In Argentinian footwear, the Argentinians justified their actions, a statistical fee that they had imposed, on the basis that the International Monetary Fund had insisted that it should have this statistical tax. In the recent EC aircraft case, the European Union and the EC had a bilateral agreement on subsidies with respect to aircraft industry. And the question arose, how do you deal with that bilateral agreement and the WTO obligations of the two parties? So fragmentation involves conflicts and tensions between different norms. So why has this happened, and how does it implicate the question, how do you define international economic relations? It implicates that because we are engaged when looking at the problem of fragmentation in terms of subsets of regimes, how they have evolved, how we engage ourselves in subsets of regimes, and how these feature with respect to the rest of the international economic system. The quest for coherence in international law, in international economic law, is premised on some conception of what the system is about, what the aims and objectives of the system are about. Moving on to my final example is, I just, in terms of timing, we have 15 minutes more, is that correct? Okay. The question of the mandate of an international economic organization has occurred a number of times. In terms of the International Monetary Fund, for example, the General Counsel of the IMF has had to answer the question why the International Monetary Fund, an organization focused on monetary issues, failed to spot a problem of finance, of financial affairs, of banking affairs. So the response of the IMF General Counsel was, well, we are really an organization that focuses on monetary issues in terms of balance of payments, currency fluctuations, and so on, and our mandate did not cover financial issues in the financial sector in that way, and that was the justification given. In terms of the WTO, Pascal Lamy, some years back, capitulating to the pressures from developing countries, came up with the statement that WTO is not a developed institution. and many economists, I don't know whether Professor Park takes the view as well, that the WTO is not a development institution. This is a mantra that you find again in international economics and literature in law. I beg to differ with that statement that the WTO is not a development institution. I think this is a controversial political statement that has been made. It is controversial because Pascal Lamy makes that statement, but his predecessor, the Director General, never made such an assertion. His predecessor came from a developing country, from Thailand, Supache, and in fact, in his writings, he urges the WTO and makes the point that the WTO is an instrument for development. It's an instrument for development. And moreover, it is not self-evident. Not self-evident that the WTO is not a development institution. It is normally understood that it is evident, it's self-evident that it's not a development institution. I beg to disagree on that. And this assertion that it's not a development institution is also not logical and does not bear legal analysis. Why? It does not beg legal analysis. Why holistic? It is a view, it's a view that stems from international economic relations that is non-holistic. It takes a non-holistic perspective of international economic relations. It takes a view of international organization in a monolithic manner. In other words, that it sees an organization as being specialist, but really international economic organizations now are much more complex, much more nuanced in terms of their mandate, so that the idea that the WTO is only about trade is controversial from that point of view. How did this statement? He took the view that the WTO business is not to give aid. The WTO's business is not to give aid. It's not to give to financial aid. It is simply to provide a forum for the advocacy for financial aid. And he makes the point that the WTO's role is not to manage or disperse aid. It is simply to advocate aid. And for that reason, he then says the WTO is not a development institution. So here what has happened, in my view, is that there has been a jump, an intellectual leap from the question WTO is not an aid institution to the question WTO is not a development institution. It does not follow that if the WTO is not about giving aid, that it is not a development institution. In terms of legal analysis, what is the scope of the competence of the WTO, and how do we examine the competence of the WTO and this question that it is not a development institution? Is there a general understanding of what is a development institution out there? Is there a definition of a development institution in international law? What are the credentials? What is the criteria against which we speak about a development institution? Well, firstly, international economic lawyers and international economists often talk about the three pillars of international economic relations as resting on the IMF, the World Bank, and the trade, WTO. That the IMF and the World Bank, as David Vine says, IMF and the World Bank and the WTO are three pillars of the international world economy, and that these three deal with monetary and financial systems, with development policy regime, and the global trading system. Yeah? What is problematic about this statement? Myself included, until I thought about this, one sort of accepted the statement as given, but until I thought about it, actually, this is a distorted view of the position of monetary issues and trade issues in relation to development. Yeah. If you understand, and I use the word development in a broad sense of development, then you cannot possibly equate monetary issues and trade issues as end in themselves and on the same par as the objective of development. Yeah? Because the monetary disciplines, the trade disciplines, are aimed at achieving development. But if you put them on the same par, you are in a sense fetishizing trade and monetary issues. So really, the pillars of international economic relations that we tend to describe are more accurately described as the World Bank Group that is concerned with assistance for development, not development par excellence. The IMF and the WTO are considered monetary and trade spheres, respectively, for development. So the three-pillar analogy of these three regimes is an engagement, in my view, of an obsession with trade for its own sake and monetary liberalization for its own sake. The constitution of the WTO, is there anything there that sheds light on this question, whether it is a development institution or not? There is nothing in the WTO constitution which prohibits it from acting as a development institution. There's nothing in its functions and its purposes and its powers that prevent it from engaging in development related activities. In fact, insofar as the WTO jurisprudence is concerned, the appellate body regularly relied on the fact that nothing in the WTO agreements prohibits, and therefore it is something that can be done. The purposes of the WTO clearly mention development in the preamble. And so, based on a legal analysis of the Articles of Agreement of the WTO, one would conclude that there is nothing there that prevents the WTO from being a development institution. And indeed, one might even say there is authority there for the WTO to focus on development issues. Is there a legal definition of a development institution? What are the attributes of a development institution? If you examine the various international development organizations under the United Nations system, you will see these are actually the UN Development Group of institutions. Each one of them engages in the development enterprise in a different way, through aid, through providing a forum, through providing technical assistance. The focus is different in terms of women, welfare of women, in terms of drugs, in terms of refugees, and so on. So all of these, there's no archetypal development institution out there. All of these development organizations engage in the enterprise of development in different ways. So, just to go back, labels, of course, are important in describing an organization. So the WTO is about trade. It's a World Trade Organization that focuses on trade. But to use that label to negatively make the assertion that the WTO is not a development institution is, I think, is an inaccurate description of what a modern economic organization is about. Mandates of international economic organizations are much more subtle, much more nuanced, much more complex than this. When I was looking at this topic, I don't know whether you've seen, just 5 more minutes more, whether you've seen Tootsie, the film where Dustin Hoffman acts as disguises as a woman actor because he couldn't get a part as a male actor. So he manages to get an acting part as disguised as a woman. And then in the end, of course, he gets fed up with having to carry this fraudulent identity that he had created for himself. And he makes the assertion in the soap opera that he was making, he reveals himself to be a man. But he makes one very profound comment in that film, and that is that, in all of us, there are elements of the male and the female. In all of us, there are elements of both female femininity and masculinity. That is how I think Pascal Lamy should have responded when he was confronted with pressure from developed countries, that he should have said the development issue, the development attribute in me, the development part of me dictates this, that, and the other, sort of the way he reacted at that time. So another reason why one might say the argument that the WTO is a trade institution is because the popular thinking about a development institution, that it is associated with aid, that development institutions are simply concerned with aid, and that the WTO, because it does not give aid, rather it works on the basis of reciprocity as between member countries in terms of market access. But this also, I think, does not stand the test of scrutiny, because reciprocity, firstly, is not the only way of achieving liberalization. It's not the only way of achieving liberalization. And moreover, reciprocity with respect to a large constituency of the WTO is not expected, from developing countries. So to conclude, the problem of the mandate of the WTO with respect to development is in essence a query about how we define subsets of regimes in international economic law and the manner in which they are configured within that system. Yeah? So this question is very much about how we define international economic law, its objectives, how we see what its objectives are, and how we define the relationships between these subsets of regimes. So, to conclude, defining international economic law for the future, any definition or conception or approach must survive the test of time and cannot be set in stone. So we must constantly examine this question: what is international economic law? The modern thinking of policy making and appreciation is that there are relationships, interrelationships between different policy instruments, both economic as well as non-economic, and that we cannot look in isolation at different policy instruments, that a holistic approach to international economic relations is required in defining international economic law. We also now have to understand that the subjects of international law, the dynamics are changing. The international community, for example, is confronted with various trade blocs who are engaging in a different way in international economic relations. So the traditional setting of international economic law in terms of the state is being challenged in terms of these new entities that are emerging in international relations. And finally, I guess if food for thought, given the modern approach to looking at policy making in terms of integration, in terms of a larger agenda of coherence, whether the international economic system as such will wither, and that whether we will look at international economic problems completely differently. Thank you.
So, ladies and gentlemen, we have had a very interesting and, in some sense, a little bit controversial view of Professor Qureshi about the role and about the essence and elements of international economic institutions like WTO and others. If you have any questions, please raise. 정민혜, 윤혜령.
As you have mentioned, there are a lot of non-economical problems and concerns. For example, like human rights and environmental issues. Do you think WTO should consider more about those issues, or should it focus more on just economical and trade issues?
Well, I echo the sentiment that is said in your question, namely that that we need to, whether in the WTO, in the IMF, or wherever, we need to look at policy issues in an integrated way. We cannot divorce purely trade issues from non-trade issues, and arguably the WTO actually does not set out to do that.
So the WTO has already started to take these issues into the agenda of the WTO. So that's what Professor Qureshi wanted to answer your question. Other questions? In other lectures, you raised many. I saw many hands raised, but Professor Qureshi was too good a lecturer, so that you don't have any questions, or any questions related with international economic law or international economic organizations? 설장환, use your microphone.
I'm sorry, I don't know if I misheard your presentation, but on the part when you said that WTO is an instrument for development but not a development institution, when you said that, and you do not agree with what the person said, can you please?
Pascal Lamy said WTO is not a development institution.
You do not agree with?
And I disagree with the statement, the negative statement, that the WTO is not a development institution. And for the reasons that I set out, namely that it doesn't bear scrutiny in terms of the definition, if you like, in international law or common understanding is a international development institution. It does not bear scrutiny in terms of the charter of the WTO agreements, and it is flawed in the sense that it is based on the idea that trade and monetary are on the same par as development issues. I'm simply challenging that negative statement, but if you ask me what is it that I think whether the WTO is or is not a development institution, I would say that it has attributes of development functions.
Professor Qureshi, I have one question about your view of WTO, not as a development institution, but as a institution who should take the responsibility of helping development of developing countries, right? Through the channel of international trade, through channel of capacity building, and so on and so forth. Does it have to do with the changing composition of the WTO membership? I mean, when we have got the GATT launched in 1947, we had only 23 countries. And the signatories of the agreement were mostly developed ones. So that we were not concerned about development itself, we were concerned about expanding trade to bring about growth and co-prosperity, we can say. And with the many developing countries acceding to the GATT as well as to the WTO after 1995, we have got the new dimension, so to speak, with the increasing number of developing countries as well as increasing voices raised by the emerging markets, the BRICS, for example, countries. So does it have to do with this composition, a changing composition of WTO membership? I mean, one indication is that the supposed to fail negotiation, which is termed the Doha Development Agenda, is the first time that the multilateral dealing system took development in the title of its negotiation round. So how do you think about that? Or was GATT and WTO from the beginning a kind of invented as an organization or as an institution to take development as a one of its agenda?
Yeah. I mean, my argument that my challenge that it is not a development institution is not based on the constituency of the WTO membership, although of course you're quite in saying that the thrust of the WTO and the Doha Round agenda reflects the new constituency and the voice in the WTO, for sure. But I have more fundamental problems with the idea that it is or is not a development institution that is not based on the constituency aspect. The Doha Round, and well, it's slowly getting buried and buried. Although a year or two ago, I think I would have said, "Oh, these are all political machinations of the international dynamics," but now even that is difficult to say about the Doha Round.
Other questions? Daniel?
If you believe that the WTO should act as an institution of development, how would you go about getting them to change their focus or policy?
My query, my concern or my irritation is with respect to the statement that it is not a development institution. Yeah, I'm not advocating that it should be a development institution and what follows from that. I do think that the assertion, the negative assertion, it's not a development institution, had important implications, for example, in terms of the ongoing negotiations. I think it was not a helpful statement perhaps to be made in that context of the ongoing negotiation. I also think that Pascal made that statement as the Director General of the WTO, and that sends an important signal within the Secretariat, and for example, if cooperation, they should engage in development assistance to the extent that they do give technical assistance to developing countries. It also sends a message to potential donors to the WTO with respect to what kind of assistance it need. I think it may send a chilling effect on potential donors because they would say, well, it's a trade institution, it's not a development. Why should I on this instance? So there are implications about that statement in that way. There are also consequences. The Director General is not an organ, or he's an organ of the WTO, but he's not charged, cannot interpret the mandate of the WTO. But the appellate body and panels have in the past taken statements made by director generals in arriving at their decision. And trade, as you know, regardless of the question whether the WTO is a development institution or not, trade issues can involve questions about development. Can involve in response there is possibility of the way as I made.
Yes, we have slowly broken ice, so we have several hands here. Jamie?
Hi, so you said that as a lawyer, it's important to make distinctions between public international law and domestic law. And we're talking about the WTO and about all the muddled kind of in-betweenness, how it's hard to distinguish one thing from the other. How can you remedy this if we need these more strict legal definitions, but everything kind of overlaps? What should be done to build consensus?
Not quite sure if I answer. I mean, from a legal perspective, it is important to understand the distinction between public international law, treaty law, customary international law, and domestic law. For example, if you conflated the two and you went and litigated in the Korean courts and you invoked international law or the WTO agreements, you would be told to shut up because you would be told the WTO agreements are not part of Korean law, and so it has no relevance. That is a different system of law, those are different standards, they're not part of the domestic law. So simply as a matter of from a legal standpoint, from a technical legal standpoint, we need to make a distinction between the two systems. The argument that you need to look at international economic law and define it both in terms of domestic law and international law, I mean, legally it's not sound. It is simply a proposition that this is how international economic law should develop. It's trying to, it's a proposition that's trying to de-emphasize the role of the state, to engage private entrepreneurs and private individuals in the process of foreign economic policy making through the court system and otherwise. I don't think there is any doctrinal difference between the assertion that international economic law is part of public international law or international law is both. I don't think there is because those who claim that it is a specialism of public international law do not deny the fact that public international law has to operate within the context and the background of domestic law. So there's no doctrinal difference, although there has been a doctrinal difference that has been portrayed as being there in existence. I think there's no opposition to that as such. But to matters even I didn't mention, but I'll take this opportunity, is that there is yet another twist to this definition of international economic law, namely that the assertion that international economic law set out in treaties, the Bretton Woods institutions, the WTO agreements, really reflects the comparative advantage model, that international economic law, the thrust of international economic law, the model of international economic law is about dismantling the state system. It is about dismantling borders between countries, whereas public international law is really about defense issues. It's about taking a mercantilist approach. It's about the interest of the state in economic affairs, whereas international economic law is concerned about global welfare. So in that way, the idea that it is a specialism of international economic law is challenged.
Okay, 장인철.
All right, firstly, thank you for your presentation. And my question is a bit related to the climate change and like climate issues, environmental issues. And after like Kyoto protocols and Rio conference, and we're saying that sustainable development is important issues. And in order to develop, we have to focusing on how we decrease the level of emissions, like emission things. So some said we have to do emission trading systems. Like for example, one country's emissions level is higher, then they can trade between smaller countries who emissions level is lower. So in that case, what will be the best way to conserve the environment in terms of like development? What will be sort of best way to develop when we protect the environment? Bit like rush question, but
I don't know. How does this question touch upon the question of defining international economic law, or the question of defining subsets of international economic disciplines, or the way they are configured, or their relationships with each other?
So,
But I think it is very difficult for law professor to answer this question because it involves a lot of technicalities, right?
yeah. So
Which is the optimal way to conserve the environment. That is not really relevant question on this issue.
okay. Thank you. Anyway.
So Laura.
Thank you for your presentation. I was wondering if you could elaborate further on your point that further policy integration and coherence could lead to the falling apart of the international economic system, and if in fact it could be argued the opposite, that the international economic law system could become even more relevant through that process.
I don't understand the latter part of your question. If you could just repeat.
As countries try to bring together their policy to create a more coherent policy process, could the international economic law system become even more relevant during that process? I don't know if that makes it any more clear.
Okay, but I'm not sure, but I think the first part of your question, perhaps the second part, is just a converse of the same
Yes.
question, really. I'm just throwing the idea that we are gradually, as we are developing, changing the way we look at the economic phenomenon. Yeah? We're now no longer looking at economic at problems purely from an economic dimension. We think about human rights, we think about labor rights, we think about environmental issues, and increasingly when you talk about coherence, that's what we are thinking. So I'm just thinking, sure, more stabilized, and as the world economic system or the international dynamics or and the way we think hundreds of years down the road, that might stop looking at economic purely in terms of that we bring approach problems. We look at them from a holistic, and therefore, if perspective. Whether you no longer look at economic problems or from the lenses of the international economic system.
Ashley?
Hi, thanks for your presentation. We've been talking a lot lately in this class and my other ones about, FTA and trade and things like that. So my question is, if being a government person, if I was an actor in my government, do you think that there's some kind of issue with sovereignty between the nations? Do you feel like nations feel like they have to give up an element of their sovereignty in order to accommodate for international economic law, like maybe in the case of Apple, Samsung, or other ones?
Well, the one view of, if I understand your question correctly, is that you're asking whether joining free trade agreement, whether joining the IMF, whether joining the WTO, whether signing up to involves a. That's essentially your question. And one view of that actually, of course, it depends on how we define sovereignty, but that actually joining institutions and regional institutions enhances state sovereignty rather than diminishes it. It enhances sovereignty because if you don't have multilateral institutions, international multilateral agreements, then the state is hostage to rent-seeking lobbyists within the state, and decisions are made in a distinct way, and the agenda of the state is by powerful lobbies. Whereas if you shift those decisions to international economic organizations, then what is happening is that the sovereignty of the people is restored and taken away from the lobbyists because the decisions are now insulated in international economic organization. And moreover, given the negativity that is also associated with globalization, states need to cooperate in order to with the aspects of globalization. So in that sense, again, it is sovereignty enhancing to join international economic.
Okay. Lily?
Good afternoon, Professor. I have two questions. First, about the international economics law. Because the source for international economics law is based on the treaty that's signed between country and country. So why don't we call it as the international political economic law? Because when we think of the economic, this term, it might be very, just like maybe between the company and company instead of state with state. So whenever it is involved between state and states, why don't we term it as international political economy law? And my second question is about WTO and China. Since we know that China successfully became a member of WTO in the late 2001. And after that, China became, until now, China became the second largest economy in the world in 2011. So in your opinion, do you think that actually WTO helps China to become the second largest economy in the world, or actually it is not related? Thank you very much.
Yeah, thank you. I mean, the first part of your question, really, what you're saying is just echoing the assertion, the school of thought that says that international economic law is really public international law. You are using the word political economic law, but I think that might be a bit sort of the word political, but I think more accurately what you're trying to say is that because most of international economic law is treaty-based and in part customary international law, it is better described as public international law, a branch of public international law, a specialism of public international law. So in that sense, I would agree with you that that's one way of looking at international economic law. China's progress and the WTO. Well, I'm not an economist, so I would say the causal connection between its economic rise and its entry into the WTO is better answered by an economist. But one would suspect, of course, that joining the WTO meant that markets were open to it, and therefore it was able to grow as an economy.
I have not done a specific research on that, China's accession and China's economic rise. But I think, as Professor Qureshi mentioned, China's accession to the WTO has expanded China's market with regulated protection from others, right? If China did not join the WTO, then the WTO members could have elected new trade restrictions on increasing exports from China. But because China joined the WTO, the other countries could not do that due to regulations stipulated in the WTO agreement. So certainly, in my view, China's accession was a contributing factor to that. But I think it is not all the story. We have a lot more factors contributing to this development. We have to study that in a very rigorous modeling, but I did not do that yet. And I don't know any research which was done on that issue. Ladies and gentlemen, GSIS does not have a pure law professor, right? We have courses like international law or international economic law, which is not taught quite frequently. So that languages used by Professor Qureshi and my language could be quite different from one another. So that in the beginning you had some hesitation to raise questions. But with time, I think we have got several good questions relevant to Professor Qureshi's presentation. Thank you very much. I think when it comes to the WTO and relevant issue, as explained by Professor Qureshi, we have to take a look at the main principles of the multilateral trading system. I don't know whether Professor Qureshi is supporting my view, but my economic interpretation of the WTO's main principles are: number one, WTO has the principle of non-discrimination. Number two is fair and freer trade. And number three, there comes supporting the economic reform and development that is implanted as one of the main principles of the WTO. If you think about that, then certainly I do agree with Professor Qureshi to his point that the assertion by Pascal Lamy that the WTO is not a development organization, it is not right. Even though WTO is not focusing on development issues, WTO should take this responsibility to support the development process of member countries, especially developing and least developed countries. They are doing that, and WTO is also doing that as well. Do you agree?
Thank you for the vote of support there.
Thank you very much, ladies and gentlemen. Why don't you give him another big applause for his excellent job.